Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Demaray. I like to say that Michael is the Matt Dillon of litigation practice here in Santa Clara County. He's the first one they look for and the last one that they want to see.
Call me Lindsay Lohan.
Okay. He's also a little bit of a diva. Anyway, he is a California attorney, principally works on lawsuits involving estates and trusts. Well known here in Santa Clara County and a good friend. Mike also is a graduate from Hastings School of Law. So before we get started, we're going to be talking today about your rights as a beneficiary. And we have to say, get independent counsel. We also have to say, we're California practitioners and beneficiary rights can be different in other states. So if you're watching and you happen to be in another state, it's especially important that you get local legal counsel. Mike, thanks so much for joining me today.
Mike, my pleasure.
Okay. All right, Mike. A close relative died. How can I find out if I have an inheritance?
Well, if it's Mike, you, I would doubt that you'd have anything at all. But
Thanks a lot.
other people, there's really no central clearinghouse as such to find out. There are certain laws in the state of California that are supposed to inspire the people who have control of the money after someone dies to turn it over to you. Mm-hmm. But there's really no central clearinghouse as such. Now, there's one exception to that, and that is you've probably heard the word escheat, E-S-C-H-E-A-T. That means there's a lot of money out there in bank accounts that nobody picked up and has gone to the state of California. The state of California holds onto it for a number of years. You may find that there's some money out there that belongs to you from some relative or friend that was never picked up. And you can go to the state controller's website to look that up. But other than that, there's only one of a few things you can do. When people die in California, they die either what's called intestate, that means without a will or a trust, or testate with a will or a trust. If they die intestate, their money can only be transferred through what's called probate. Mm-hmm. There eventually has to be some order of distribution from a probate court that transfers it from one person to another. So if there's a piece of real estate, that real estate's going to stay in the decedent's name until somebody goes around and starts probate. If they start probate, they are supposed to give notice to the heirs. These are the people that inherit under the state of California: spouse, children, grandchildren, brothers and sisters, nieces and nephews. Mm-hmm. So you'll get notice in the mail of that. You're supposed to. Uh-huh. If you die testate, you either have a will or a trust, or maybe a combination of both. If you've got a will, the will is supposed to be lodged with the probate court within 30 to 60 days after the person dies. But you wouldn't necessarily know about that. How can you find out? Well, you go down to the courthouse, you ask to see the list of original wills that have been filed, and they'll show you a list of original wills, and you may find somebody who you know. Most of us don't do that. Usually, again, with a will, the property can only be changed with a court order. In order to get that court order, you got to start probate. With probate, they got to give notice not only to the heirs, but the people that are the beneficiaries of the will. So that's another way you'd find out. Mm-hmm. If you have a trust, that's a bit more problematic. We have a lot of people that have a lot of trusts these days. And the reason people enacted or started signing trusts is because they didn't want to go through probate.
Right.
So you don't have to go to probate court to enforce, or I should say, distribute a trust.
Right.
So how am I supposed to find out if I'm a beneficiary of a trust? Well, the law says that the trustee is supposed to give you a notice, a notification by trustee within, I think, about 60 to 120 days after the decedent dies, saying this person died, and if you'd like a copy of the trust, we'll send it to you. Mm-hmm. And then you write in, and they will send it to you, and you'll find out that way. But if they don't, you may never find it. Even if that person owned a piece of real estate, the person who has the ability to transfer it is the trustee. And even though the trust may say the trustee is supposed to give it to you, that trustee may go ahead and distribute it to somebody else, and you will never find out.
Well.
So what I'm saying, so that's too bad.
Yeah.
Then there are other, and it becomes even more problematic after that, because everybody knows about things like pay on death accounts,
Right.
or life insurance proceeds.
Right.
And those are just paid out to the named beneficiary. And there's no central clearinghouse to find out gee, am I the beneficiary of a bank account, or am I the beneficiary of a brokerage account, or am I the beneficiary of a life insurance policy? So there's no real easy solution to that. But there are some things you can do to try to find out. And as I said, you can go down to the courthouse, ask to see the register of wills. You hope that somebody's going to send you the notice that the law says they're supposed to. And if it's a sheet property, you can always look into the state controller's website.
Okay. My mother, let's say, was a widow. She died a year ago. I believe my brother is her trustee. I haven't heard or seen anything happen for administration of her trust. What can I do to get things moving?
Well, if you don't hear anything from your brother, what you can do is you can start the probate yourself. Either you or your brother, or frankly any interested person, that would be an heir, can file a petition in probate court saying, my mother's died, I am one of her closest relatives, I want you to appoint me as administrator. Now in order to do that, you got to give notice to your other brother. And as soon as he gets that, he's not just going to sit there and let you become administrator. He will come into court and file an objection. And in that objection, he'll have to say why you shouldn't be appointed administrator. And that's when you'll find out if there is a trust, or if, heaven forbid, he got mom to put the property into joint tenancy with him. Another way to find out is if she owns a piece of real estate, you go down to a title company and ask for a courtesy copy of the most recent vesting deed, or maybe the last 2 vesting deeds. And you might be unpleasantly surprised to see it went from mom's name to mom and your brother as joint tenants. Now, if it's joint tenants, he doesn't have to go through probate.
Oh boy.
And that's when you'll find out that you're not going to get anything if the joint tenancy deed stands up. If you want to contest it or try to set it aside, you got to go to a lawyer.
Okay.
So a couple things is you start the probate, you check with the title company, and that's basically the best way to go about it.
Sounds good. All right. Now, here's an interesting scenario, and one that I know that you deal with regularly. What if mother remarried and my stepfather is the trustee?
Now, that's a very, very common problem, especially when we've got a divorce rate of in excess of 50%, and we have children by prior marriages. Well, in the old days, one spouse would simply leave it to the other. They would trust that the surviving spouse would be fair to their children, the deceased spouse's children, as well as to the surviving spouse's own, but there's never any guarantee. And the reason we usually left it outright to the surviving spouse is because, we've been living with them for a number of years. They've been taking care of us. They're the ones that need it. And with a little bit of hope, they'll spend it all before they die. Then they developed something called QTIP, Qualified Terminable Interest Property Trusts.
Yes.
And what they do is they were designed originally to save estate taxes, but they really fit in well with second marriage situations. What they do is they say, when I die, my property goes to my surviving spouse in trust. She'll be the trustee. She's entitled to the income automatically, interest, dividends, rents. She's entitled to invade the principal for her reasonable support, care, and maintenance, but when she dies, what's left goes back to my children.
Right.
Now, there again, there's this problem with the fact that if you make her the trustee, neither the title company nor often the bank accounts, the bankers, won't ask to see the trust. And although she's not entitled to give the money to her second husband or simply pull it out, put it in her own name and give it to God knows who, she has the power to do that. What happens if she does? Well, then you got to file a lawsuit. Well, when do I have to file that? Well, some people would say you should file it as soon as you find out. But let's say you find out before she dies. If you file a lawsuit, you may well win it. Then what will happen to the money? Well, it'll go back in the trust. And until she's dead, who does that money used for? Her.
Yes.
So it's kind of problematic. You may be able to get her removed as the trustee and put somebody else in as the trustee who will not steal it like she was. But she'll probably still get the benefit of it for the balance of her life, and you won't inherit it until she dies.
Okay. I'm a beneficiary of a will or trust, and it has a no contest clause. Does that mean that I'm shut out and can't challenge the will or trust? What should I do?
No contest clauses have been around for a long time. Now, no contest clause doesn't disinherit you. In fact, it really only works if the will leaves something to you. The way it works is it says this: I've left you $10,000, or I've left you $100,000, but I left your brother $10 million. Now, you might be inclined to want to contest that trust on the grounds that you should get half because you and your brother are the only two children. The way the no contest clause works is it says that if you contest it and you lose, you don't get the $100,000 that would otherwise have gone to you. So you have to think, do I want to contest this to try to win $5 million and risk losing the $100,000 I know I'm going to get? Or do I just take my $100,000 and live with it? That's the way no contest clause works. Now, a lot of lawyers think that no contest clauses are more of a pain in the keister than they're worth, because although wills are attacked and a lot of them are set aside, it's very hard to, quote, break a will or break a trust. And there's a lot of law that's designed to uphold the validity of those things. So usually the contestant loses anyway. So what they've done now is they've tried to weaken the no contest clause by saying this: if you file your contest and you lose, you only lose what you would otherwise get if you cannot prove that there was probable cause for your lawsuit. What is probable cause? Well, they're not too careful about that. They don't define it. If the person that died was in the peak of his health and perfectly competent and nobody disputed that, that's pretty hard to prove probable cause. But if they were on their deathbed, they were in a coma, and they signed it while they were in the coma, which is theoretically impossible,
Right.
you probably have probable cause.
Okay. I'm a surviving spouse, or I'm a child of a decedent. Do I have any rights irrespective of the terms of the trust or the will?
Of the will and the trust, the will, yes. Of the trust, not so much. Now, this is an old holdover from the old probate days, and it's too bad. If you have a will and you have a wife or minor children, your will can say I leave my half of the property to anyone I want. When I say my half of the property, I'm assuming it's community property.
Okay.
But I could also say my separate property, the property I owned before I got married, or the property I inherited after I got married. I leave that to my friend Michael Gray. And theoretically, I don't have to leave it to my wife. I could have been married to her for 50 years. I don't have to leave her a thing. But if I have a will, even if I don't leave her anything, she has two sets of rights. One's called a family allowance. One's called a probate homestead. The family allowance is like post-death spousal support. And it says during the probate period, she is entitled to money to support her for the period of probate. Usually you take a look at how much income she has, how much she needs, and she gets the difference from the probate estate. She gets it automatically. Probate homestead is a bit more discretionary. The probate homestead says, and she gets to live in the house for a period of time determined by the court. Might be a year, might be 10 years. If it was a long-term marriage, it might be for the rest of her life. She doesn't get to keep his separate property house, but she can get the court to order that she's entitled to live there for a very prolonged period of time. Works the same way for minor children. However, with a trust, you don't get those rights. There's no such thing as a family allowance or a probate homestead with respect to a trust. On both, there's something called a predominated spouse or an omitted spouse. And what that says is this. That says that if I had a trust or I had a will, and then I got married, and I didn't change my will or my trust to at least acknowledge that I had a wife or a husband, and then I died, the husband or the wife would get the share of the estate they would otherwise have received had there been no will or trust. Let me give you an example, Mike. Let's say that I did a will leaving or trust, leaving what I had to my two children. And then afterwards, I met the girl of my dreams and I married her. And I was so happy I forgot to leave her anything in my will. And then I died. Well, my children would come forth and said, okay, thanks for taking care of Dad, now get going. Is she without any rights? No, she's entitled to get what's called an omitted spouse's share. If he died with $10 million of separate property, let's say, and there's 2 or more children, she gets a third under the laws of intestate succession. So in my example, she gets $3,333,000. If there's 1 child, she gets half. She gets $5 million. So there are those rights as well. And of course, there's these community property, separate property rights for spouses. You always get your own half of the community property. You don't inherit that from your spouse. It's yours, even though your husband may not have been telling you about it. What is community property? What is separate property? Well, what you owned before you got married, and what you acquired after you got married by a gift or an inheritance is your separate property. Pretty much everything else is community property. So if I owned a small business and I married, then not only is the income that I made through the business community property, but if I wasn't taking out enough to fairly compensate me for my labor, part of that business, which was separate property, each year becomes a little bit more community property. So that by the time I died, if it was a 20 or 30 year marriage, half the business may be separate property and half may be community property, in which case the widow is going to get at least 1/4 of the business, her half of the community property.
Okay. Let's say I have to take the executor or the trustee to court. Can I recover my legal fees?
Usually not. The rule in this country is that you pay your own lawyer's fees. It's kind of funny because we think that our laws come from England. In England, they have what's called basically a loser pays philosophy, where if you lose, you pay the other side's attorney's fees. We don't like to do that in California or in the United States as a whole, because the lawyers are afraid that it would dampen the number of lawsuits. In other words, it's a lot more frightening for me to file a lawsuit if I know that if I lose, I got to pay your lawyer's fees as well as my own.
Right.
So we generally have the American rule, which says you pay your own attorney's fees. But in certain kind of circumstances, where you sue an executor or your trustee and you win, you may in fact get your attorney's fees recovered out of the estate or out of the trustee's or the executor's own pocket. There are 2 main theories. One is that if you can prove that the executor or the trustee acted in bad faith, you can get the court to order that he pay your attorney's fees. That's very rare. Another rule is what's called the common fund theory. And the way that works is this. If there's an executor or trustee and there's, say, 5 beneficiaries, and one of them sues to remove the executor or the trustee because he's investing poorly, the other 4 don't want to get involved with it because they don't want to spend the money on an attorney. And that 5th one wins, and he gets them removed. The law says because the others didn't have an attorney, and in fact got a free ride from the benefit of getting this guy replaced, the one that won can go into court and ask the court to pay his attorney's fees back out of the estate. Now, he was getting 1/5 of the estate anyway, so theoretically 1/5 is still coming out of his pocket. But recovering 4/5 of your attorney's fees is better than recovering none.
Right. How long does it usually take to administer an estate or a trust?
Well, that depends upon a lot of factors, but usually the main one is if it's all cash or securities, publicly traded securities, 6 months. Keep in mind, you don't have to file a federal estate tax return unless the estate's at least $5 million. Most estates aren't that big anymore. But if you do, you don't have to file the return for 9 months. And you never file and pay it early because you get to keep the interest on the money for that 9 months. So in those cases, you'd have at least probably 9 months. But if you got real estate, or especially if you have a closely held business, those can go on for more than a year. First, the real estate, you got to sell it.
Right.
You got to get it on the market, get bids, qualify, all that kind of thing. If it's a closely held business, it's even more difficult. Often there's not a market for the business because the business really was the guy that was running it. When he died, it didn't become worth very much. Or maybe it's about to go public and you got stock options and things like that. Well, that can be a big, big deal. And that may go on for a year or 2. Now, people often think that until probate is over or the trust administration is over, nobody gets anything. Not so. During the period of either a probate of a will or an intestate estate or the administration of a trust, The executor and the trustee can make what are called either preliminary or partial distributions. They can look in the bank, say we got plenty of money to cover certain contingencies, so let's start giving the money out now, so you don't have to wait for a year or 2 years before it's all over.
Right. Okay. What accountings are required for estates and trusts, and when do you think it's appropriate to waive an accounting?
You know, people have to be very careful about this. Every time there's an estate or a trust, there has to be an accounting. Law says the executor or the administrator of a deceased probate estate has to have an accounting done before they'll let you make the final distribution. In a trust, the trustee doesn't get discharged, relieved of liability, until he does an accounting. Yet many, many times, the lawyer for the executor or administrator, or the lawyer for the trustee, will send a letter to the beneficiaries or the heirs saying, would you do me a favor and waive the accounting? We can get the money out to you a lot sooner. And people think, well, that's music to my ears, I'll sign it. The problem is if you waive an accounting, you don't find out what he did with the money during the year, maybe 2 years, maybe longer, that he was administering the estate. You don't know what happened to the money that came in, the sales proceeds, unless you get that accounting. Now, you know, they'll tell you, well, accountings cost money and they're time consuming. That's hogwash. Accountings that you do in probate or for trusts are what are called cash basis accountings. You keep a check register. The accounting says this is what was there at the beginning, that is when the person died. This is what's come in. This is what's gone out. These are the gains and losses on sales. This is what's left. All balances, everything's copacetic. It details every date, every transaction, every dollar amount. And it doesn't take that long to do it. It really doesn't. Frankly, if I'm representing a trustee, I always do an accounting anyway, because I know my trustee client won't get his discharged. He won't be relieved from liability unless I do that accounting. But believe it or not, for trusts, even if your trustee does an accounting, he is still liable for lawsuits up to 3 years after the accounting is done. So sometimes what I do is I ask the court to approve the accounting just to cut off that period of time. Mm-hmm. But often I don't. It depends.
Okay. I have about 5 minutes left. I've got lots of good questions here. I'm going to throw this one to you, though, because you're in the thick of this sort of stuff. What sort of suggestions do you have to keep peace in the family of a decedent who had children from multiple marriages or relationships? And I know that's a one-day question, but maybe you can throw out a couple.
Leave everything to your dog. Leave nothing to the kids. Obviously, I'm speaking a little tongue-in-cheek, Mike. But you know and I know that most children today are not as interdirected as we are. Mm-hmm. Now, maybe part of it's our fault. There aren't the economic opportunities that you and I had. But our children often, especially if they're raised in Silicon Valley, they're used to a pretty nice lifestyle that we've supplied them. Mm-hmm. Yet, on the other hand, when they turn 18, they want their freedom. In fact, they want their freedom by the time they're 14. However, along with their freedom, they still expect you to supply them with the same lifestyle that they've always enjoyed. Mm-hmm. So they often think of your money as theirs or their future inheritance as opposed to yours. A general rule is that if you treat each kid equally, which is a misnomer in itself, that may help alleviate the problem. However, human nature being what it is, I've seen a very wealthy man marry a woman that is not as wealthy and leave his property half to her children and half to his own to keep his wife happy. Mm-hmm. I've seen other men say, no, I'm leaving it all to mine. I made it, it's theirs. Mm-hmm. People file lawsuits because they can, because they want to, not often because they're going to win or because it's fair. And the misnomer that I spoke of is, what does leaving the property to your children or your stepchildren equally mean? We didn't treat our children or our stepchildren equally while we were alive. Some got benefits in some ways that others didn't. Spent more time playing baseball with our son than taking our daughter to tea and cookies with her friends. because that's what guys do. Why should we leave as much to the son as we now leave to the daughter? In today's day and age, women still do not have the same economic opportunities that men do. It's still largely a man's world. Maybe we should leave more to our female children than our male children. But human nature being what it is, they don't see it that way. And you're not going to be around after you die. And if there's going to be a fight, it's going to be because of what they think they didn't get fairly, how they think they didn't get fairly treated. Whether you treated them fairly or not is not the point. So there's no real way to treat your children equally or to even treat them fairly. But I can tell you that if they go to a lawyer, and I'll give you an example. The uncle had $10 million. He had 4 children. And he left the $10 million in 4 equal shares to the children. But the last year or two before he died, he gave some expensive coin collection, a few $100,000 of gifts, mattered to about $250,000 to his daughter. Then he died. The other 2 of the 3 other children are furious. They want an equal share. The bottom line is that the judge is never going to give him a quarter of that $210,000. Because from the judge's point of view, that was an entirely appropriate, unequal distribution to make.
Okay. Mike, we're all out of time. Thanks so much for being my guest today. Folks, I think you'll agree with me. This is a fascinating topic. We obviously haven't covered everything because that's why we have people like Mike. And anyway, but I hope you'll think about it. Tell your friends to watch it on YouTube. And we'll see you next time on Financial Insider Weekly.